So, you want to know what the lessee under that lease is going to be authorized to do with the surface. They may have the authority to drill a well wherever they want on that piece of property. They may also be able to put up a number of other facilities. Just, it really just depends on the terms of the lease.
Welcome to Deals and Developments, a real estate podcast from Dykema Gossip PLLC. I'm your co-host, Teresa Ereon Giltner, a member of Dykema and a member of the firm's real estate practice group.
I'm Megan Knell, partner here at Dykema and a member of the firm's Energy and Natural Resources group. For more episodes, you can find us at dykemapodcast.com or youtube.com/dykemalaw, or by searching Deals and Developments wherever you get your podcasts.
On today's episode, we'll be discussing how minerals and surface rights affect real estate development in Texas. As a reminder or a base for our discussions this morning, Texas title commitments and related owners and loan policies may contain references to mineral interests and often do, but they're not guaranteed in any way, shape, or form that by the title companies or the issuing underlying insurance companies that those are the only mineral interests that affect a property. And because of that, we don't know always what is actually out there unless a separate mineral search is done. So let's jump right in. One of the first things that we look for on the real estate side in reviewing a title commitment where mineral issues show up is whether those minerals are severed from the surface. Megan, can you explain to us what severed from the surface means and why that's important?
Sure. So in Texas, you have the ability to essentially separate surface rights from the mineral rights. So the surface may be owned by different parties than the parties who own the mineral interests that underlie the surface. You can kind of think about it as two separate roads, right? So your ownership of the surface may follow road A, and your ownership of the minerals may follow road B, and they may or may not be the same owners depending on the title to the property.
Okay. And let me also say, kind of as a base, that this is becoming more and more common as we're reviewing title commitments and looking at title for on real estate, because development is pushing further and further out into areas that were previously obviously undeveloped and perhaps used as farmland or was just raw vacant land, often commonly used in some way for agriculture, I think. But because of that, back then, maybe the cows or the hay, they didn't care whether there were any minerals out there, right? But as humans and going to develop that property perhaps into multifamily, perhaps into single family residence on lots, or perhaps a new shopping center. Or I saw just recently that there was a new Costco that was being developed out in near West Texas. I mean, I'm sure that area, when they look at that, will be will be covered in mineral interest. It's just kind of the way of the world in this neck of the country. So
Yes, no, that's exactly right. And I think that, historically too, kind of to that point, we've seen oil and gas development in more rural areas. And in the past 10 years or so, we've seen it in urban areas. So, for example, the Barnett Shale that's right in the heart of Tarrant County, Johnson County, et cetera. And so, you are seeing these sorts of issues arise more frequently now that we're seeing development move further and further out from the urban cores into these sorts of, what were once more rural areas.
yes, absolutely. In fact, I have a client who is looking to develop a tract in Johnson County as a multifamily. Another client who wants to develop it adjacent property. They're kind of working together as single family residents, and they were able to find a company that can do a mineral search for them, just to be able to identify, what minerals are out there. So going back to minerals, if they're severed, I guess it's necessary to identify who owns what out there. Correct?
Right, right. No, that's absolutely right. And, maybe going down a little bit of a rabbit hole. I mean, the mineral rights under the surface can be further divided so that certain rights attributable to those mineral interests can be kind of divided up. So, for instance, we have what are called executive rights that are connected to the mineral interest. And that gives the holder of the executive rights is the one who has the ability to actually lease the mineral interest for oil and gas development. So, you know, for purposes of surface development, yes, you certainly want to identify any existing mineral severances. And it may be, that all of the minerals have been severed from the surface. It may be that only a portion of them have been severed. So once you kind of identify what has been severed, then you need to determine if those minerals have been further kind of divided up such that the executive rights are not necessarily held by the mineral interest owner themselves.
Okay, that makes perfect sense, because I know that oftentimes we will be trying to get those surface owners to waive their rights in, as to our particular track. Clearly self-serving, but also just acknowledging kind of the emerging use of what that property is going to be on a going forward basis. Because if the property is ready to be developed or is at the point where it's being developed, whether it's our client or it's somebody that comes after them, it's probably only a question of when, not if, the property is going to be developed. And for a surface owner with executive rights, that can create their own problems, right? Because they thought they had all of this land, and now we're coming to them saying we want to put you in this corner, where you can, it's okay for you to conduct your operations from there. That may have its own ramifications, but we don't want them to have wide surface rights, for example, because most people don't want to have an operating well in their backyard, even if that would be to be allowed by a municipality. So,
Exactly. No, I think that's absolutely right. And I think you hit the nail on the head with if you identify these things, before you get started on the purchase of the property, the development of it, you can kind of head those types of issues off at the pass. Before you get into a situation where you absolutely have to deal with it and then nobody wants to actually address the issue at hand.
right. It's also potentially more expensive on the buyer side if those haven't been addressed, because then obviously the surface owner holds the rights, and they may hold the keys to your literal kingdom, so to speak, if you don't get that resolved in the due diligence or the feasibility period. Well, let's switch gears a little bit to oil and gas leases. Obviously, we check and see as well, to the extent that we have that information on the title commitment, whether there appear to be any oil and gas leases in existence on the subject property, which is often hard from my perspective, because we'll have a lease that may go back to in the 1920s or the 1930s. We also may have a lease that's more recent, from like 2015. But it's hard, you never know which one may be the active lease, or maybe they're both active. I mean, it could very well be that one from the 1920s is still a very active lease, and the one from 2015 turned out to be a dry hole, or stopped producing. Is that accurate? Or
No, no, that's absolutely right. And I think that what you're describing is why, the mineral interest and the estate related to it can become so complicated, because the mineral interest may not be owned 100% by one person. I mean, let's say that you have 5 different mineral interest owners and they each own 20% of the minerals in a 100-acre tract. Each of them have the ability to execute separate oil and gas leases. And those could have, if the minerals were severed from the surface in 1920, you may have multiple leases over the course of the last 100 years. And it's rare that you will see a release of those leases. So it's very difficult when you are just simply reviewing the deed records in the particular county to determine whether or not a lease is still in existence. I mean, by the terms of it, it may say that it was only for X amount of years, but typically it will also include language that says, and for so long as there is production from the property, and then that's kind of very generally speaking. And so that's when it helps to get, an oil and gas professional involved, whether that is a landman, whether that's an oil and gas attorney, because they can help you pull the oil and gas records from any wells that may have been drilled on that property, on that lease, and help you determine whether or not those leases are in fact still in effect. And you can either rule out those leases as being problematic for you, or there may be some that you flag and say they are in fact in existence. And so if that's the case, right, then you're going to need to get copies of those leases, which that's kind of another layer to this issue, is that a number of times you don't have the actual lease document available in the public record. And so then you have to track down the parties to that to try to get the actual lease so that you can see what the terms of it are. And so I guess that kind of leads me to the next point, right, is that we need to know what sort of use of the surface is authorized under the terms of the oil and gas lease that is still applicable to that tract, right? I think, Teresa, you had mentioned you don't necessarily want a well in your backyard. And so, you want to know what the lessee under that lease is going to be authorized to do with the surface. They may have the authority to drill a well wherever they want on that piece of property. They may also be able to put up a number of other facilities. It really just depends on the terms of the lease.
No, that becomes very important. I know, like, oftentimes we will try to get an affidavit of non-production from the current owner of the land in question, just to tell us, that none of the leases out there are operative. But depending on how long the person has owned the land, that may or may not be helpful. I mean, if they've owned it for 20 years, maybe there's a comfort a little bit. But as we know in Texas, as oil and gas drilling techniques become ever more precise, there are leases that maybe went dormant and, depending on the terms, may resurrect themselves. Or maybe weren't producing a lot, but were producing a small amount. And sometimes the landowners, while you think they would know, they don't know, whether or not anything's out there. So
No, you're absolutely right. And you spoke about techniques, right? I mean, I think most of us are fairly familiar with this idea of horizontal drilling. So you may not necessarily see the well pad or a well head anywhere on your property. It could be 2 miles away from you, frankly, but you might have a well that is bottomed right under your tract. And so, if you just go out there and physically inspect this 10-acre tract of land, you may not necessarily see anything that indicates there's an existing lease. So, yeah, I think certainly, doing your due diligence in regards to what exists out there, what the lease terms are, is extremely important in terms of surface development.
okay, and what about, like, if they're for surface damages? I mean, what if there's an abandoned well? I mean, if there's an open wellhead, or just an abandoned. I mean, it's there, but clearly been abandoned. But still, you as a potential owner of the property still have to deal with the fact, or somebody has to deal with the fact, that there's an open wellhead out there, and it may be that the current owner hasn't dealt with it. But if you want to develop that property, it you can't just leave it open. So what happens in that scenario?
Right. So this has become a real problem in the last several years, and so much so that the Railroad Commission had actually begun an initiative of raising funds that are kind of kept in a pot for these types of abandoned wells. I mean, it may be that a well was drilled 50 years ago, and the operator who operated it 50 years ago is long gone, and nobody knows, there's no one really in charge of it now, right? So that's the point at which you need to go to the Railroad Commission and work with them, if it's not already formally plugged and abandoned, to have it formally plugged and abandoned, so that you can develop. I mean, obviously there will always be that that well out there, but if you permanently plug and abandon it, it significantly decreases the odds of there being an issue, and allows you to kind of plan development much easier. Or the flip side is too, if it's a more recent lease, a more recent well, the operator that is of record with the Railroad Commission is operator of that well, has a duty to properly plug and abandon it if it is in fact no longer producing. And so that may be the other alternative, is that you track down the owner of the well and work with them to get it plugged properly so that you can move forward with your development.
Okay, and Megan, what as an oil and gas lawyer, what do you see, I guess, locally or around the state in terms of municipalities banning, you know, oil and gas production in certain types of areas? I mean, are you seeing any zoning that or ordinances that restrict that, as again as we have land that comes into an ETJ, or maybe even in a county or a city where it wasn't an issue before because it was farmland, but now that farmland is being converted into something else. So kind of even the character of the city a little bit has changed. Are you seeing anything where those cities or municipalities are taking steps to address that issue, or are they just kind of sitting back and being silent on that?
Yeah, no, I mean, I think we certainly saw it with kind of the onset of in particular, drilling in the Barnett Shale. I think initially there were at least one or two cities, municipalities that attempted to just prevent drilling altogether, which became a real hot topic because, right, essentially that acts as a condemnation of sorts for the mineral rights owners, and so you saw a little bit of a backtrack there. And so now, there are a couple of cities, Mansfield being one of them, Arlington being one of them, where they do require that you get a permit from the city to drill an oil or gas well. And they've laid out, some rules regarding those permits and how they're obtained, and how far they can be from residential areas. It may require that the operator of the well, grant some sort of security interest to the city in order to assure the city that they're going to comply with their permit and the terms of the regulation that's at hand. So certainly, I think, as the oil and gas development has pushed into these areas where we have more development, you are seeing cities kind of try to quickly get on top of how they can be involved in the regulation as opposed to just leaving it to the state, and primarily the Railroad Commission to dictate how development occurs with respect to the oil and gas in these areas.
Okay, that's good to hear because it is a difficult situation. I mean, I can see even within our own law firm, we could be representing, obviously not at the same time on the same piece of property, but we could certainly be um, representing an operator who wants to continue to operate or who has some mineral interest in a particular city or county. But we may have a developer client who wants to develop a piece of land in that same place, and they both have rights. And at the end of the day, I guess what the cities or the municipalities are trying to do is to do something fair, or as fair as that can be, without taking away those mineral interest rights and devaluing those mineral interests, but by the same time recognizing that property, the character and use of property can change over time. I mean, just as I'm looking out here in our offices in downtown Dallas, I mean, there is land that probably 50, 60 years ago, even that current, was not a part of the tollway or was not a part of a major interstate, but now is. And that's just the way that property, the character and use of property changes over time. But those mineral interests and what lies beneath doesn't necessarily. And so as a result, we have to figure out how to coexist with that. And that kind of leads me into the last question or the last kind of big topic is, what can an owner do to make sure going forward basis, if, for example, they don't want to have mineral interests or they don't want to have to deal with mineral interests or oil and gas leases, what's a tool that they can use to ensure that that doesn't happen on a going forward basis?
Sure. Yeah. So I think there's a number of ways. You had previously mentioned one of the things that you can do is get a surface waiver from the mineral owners in the property, and that's essentially just a blanket waiver of, we are waiving. And right, I mean, I'm speaking again pretty generally, and you can modify those sorts of waivers as you see fit. But generally speaking, it's the mineral owner is waiving their right to use the surface of the property for any type of oil and gas development. Now, they may decide to waive their right to use the surface, but allow for horizontal drilling, directional drilling, that allows them to drill a well under the surface, and you may require that it be X number of feet below the surface to give you some sort of comfort that, even if there's something going on under the surface, it's far enough down that it should not affect your surface development. And they may, you can just modify that how you see fit. Another way that you can do it, if they don't want to do a full waiver of all rights, maybe something such as a surface use agreement. So you enter into an agreement with the mineral owners where the surface owners and the mineral owners agree as to how the surface of the property is going to be used for oil and gas development. So you may, let's say you have a 100-acre tract. You may essentially designate 5 acres on that property that can be used for a well pad, or for some type of facility. But then, the developer and the mineral owners kind of work together to come up with a plan that will accommodate both of their uses of that property. So that's another tool. And again, in those types of agreements, you can stipulate where any pipelines would go that are related to the oil and gas development. Any roads that would be necessary to get to the well pad, those types of things. So those are typically your, I would say your best options. But Teresa, as lawyers, we can always get creative.
That's right. We can always throw in a restrictive covenant or two, but obviously if you've got existing minerals on the property, then you have to deal with those folks. I mean, it's not a question of, we're just going to pretend that they're not out there. I mean, they're there and they have rights in the property. And a surface use agreement, I think, is often, as you said, I mean, a great way. May take some negotiation, but a great way for it to be a win-win for both parties, so that property can be developed, but it can at the same time still recognize the ownership interests and the rights of those mineral interest holders. So, I mean, we'd all like to have things our way 100% of the time, but that's not the way it usually works. So.
That's right. No, and I think that, I've even, operators, I think, have become much more open to the idea of working with the surface owners, because they recognize that if the development is not there, it's pretty likely that it will come at some point in time. And there's a need to create a relationship between the parties that allows you to sort of work through these things. So, I've been involved in a couple of instances where, there have been oil and gas leases that are in place and are existing, and even existing production from them on the property. And, even working with those operators, they are pretty good about doing what they can to accommodate the development of the surface in a way that allows them to still accomplish their goals as an operator, but also allows the continued development of the surface. So, I think that the last few years have brought challenges. I think they'll continue to bring challenges, but I do think, you and I are both seeing that people are starting to come around to the idea of, if we can work together on these issues, it certainly makes it easier for all parties.
No, I think that's great. Well, I think that's it for today. Thank you for joining us. Again, my name is Teresa Ereon Giltner.
And I'm Megan Knell, and we look forward to seeing you next time on Deals and Developments.